Here's a clause I find Here's a clause I find in vendor agreements every month. The processor shall be solely responsible for compliance with applicable data protection law. Companies pay lawyers to write that sentence. Under the DPDP Act, it's worth precisely nothing. Section 8 opens with a provision that deletes an entire genre of contractual cleverness. The data fiduciary is responsible for complying with this act for processing by itself or by any data processor on its behalf, irrespective of any agreement to the contrary. Read that last phrase twice. You can allocate work by contract. You cannot allocate away responsibility. That's the spirit of today's episode. Section 8, the fiduciary's constitution. 8 standing duties that switch on when you become a fiduciary and never switch off. Consent was the permission. This is the price. You're listening to DPDP Daily. I'm Hamid Singh Kapoor. I've spent my career running large programs and portfolios, the discipline of making complex things actually happen. And for the past few years, I've brought that discipline to India's data protection law. I wrote the DPDP Act Compliance Handbook from law to ground reality, and this show is that book, opened up one episode at a time. If you're new here, the 30-second background. In 2023, India passed its first comprehensive data protection law, the Digital Personal Data Protection Act. In November 2025, the government notified the rules that make it operational on a phased clock that runs to full enforcement in May 2027. Together, they decide what every company, hospital, school, app, and shopkeeper in this country may do with your personal data and what you can demand when they get it wrong. 15 minutes a day, no jargon, real answers. Let's get into it. Let me organize Section 8 the way I teach it, as 8 duties in 4 pairs: responsibility, quality, protection, and accountability. The first pair, absolute responsibility and processor discipline. We've met the responsibility rule in the cold open. Accountability sits with the fiduciary, contracts notwithstanding, for everything done by you or on your behalf. Its partner is the processor rule. A fiduciary may engage a data processor only under a valid contract. Put the two together and the architecture from our roles episode completes itself. The law doesn't regulate your vendors directly, it regulates you and requires you to regulate them by contract. That's why the vendor inventory from the self-assessment, question 7, isn't administrative hygiene. It's the mechanism through which your statutory responsibility gets managed. And notice what valid contract implies in practice. Not a purchase order with silence on data, but terms that let you actually discharge your duties. Security commitments, breach notification to you, deletion on instruction, the withdrawal propagation clause from episode 17. When I review processor contracts, I read them against one question. If the board held us responsible tomorrow for this vendor's conduct, does this document give us the control the responsibility assumes? The second pair, the quality duties. Where personal data is used to make a decision that affects the data principal or is disclosed to another fiduciary, the fiduciary must ensure its completeness, accuracy, and consistency. Note the conditional trigger. The duty sharpens exactly where wrong data does damage: the credit decision, the insurance claim, the record handed onward to someone who will rely on it. This duty is consequential enough that it gets tomorrow's entire episode, so today just register its place in the Constitution. Its partner is erasure. The fiduciary must erase personal data when consent is withdrawn or as soon as the specified purpose is no longer being served, whichever is earlier, unless retention is required under law, and must cause its processors to do the same. The data lifecycle has a mandated end, and episode 22 walks that ending in full. The third pair, the protection duties, the ones carrying the heaviest penalties from episode 10. Reasonable security safeguards to prevent personal data breach for data in your hands and in your processors. And when a breach happens anyway, intimation to the board and to each affected data principal in the manner the rules prescribe on the clocks we've discussed since the earliest episodes. Two constitutional observations here. First, the safeguards duty extends to data being processed on your behalf. Your processor's weak security is your Section 8 exposure, which is the responsibility rule made concrete. Second, the pairing itself is a philosophy: prevent, and when prevention fails, confess. The Act prices silence higher than failure, and the 200 crore tier behind notification failures exists precisely because the old regime's silence protected exactly the wrong party. The fourth pair, the accountability duties, the humble ones that generate the most complaints in practice. The fiduciary must have in place an effective mechanism to redress grievances of data principals. A working process with the rules adding the response disciplines we'll cover in the rights episodes. And the fiduciary must publish the business contact information of a data protection officer where one exists, or of a person able to answer, on behalf of the fiduciary, the data principal's questions about her data. Pause on how radical that modest sentence is against the last decade's practice. An identifiable, reachable human, published, accountable for answering. Not a no-reply address, not a chatbot maze. When we discussed the board's design in episode 11, I called your grievance desk the first line of regulatory defense. Section 8 is where that desk becomes a statutory requirement rather than good manners. And the practical failure mode is already visible in my compliance reviews. Organizations that technically have a grievance email, nobody monitors, published in a footer, nobody finds. The duty is effectiveness, not existence. Now step back and see what the 8 duties do together, because the Constitution metaphor earns itself here. Section 8 is where the Act's fiduciary vocabulary, the deliberate, loaded word choice from our roles episode, becomes operational. A trustee doesn't merely obtain permission and proceed. A trustee maintains, protects, accounts, and answers. Every duty in this section is one of those verbs: maintain quality, protect against breach, account through erasure and records, answer through grievance machinery and a named human. The user consented was never the end of anyone's obligations. It was the entry ticket to them. One closing exercise in the spirit this arc has kept: score your organization against the 8 fast. Responsibility. Do our leadership and our contracts reflect that vendor conduct is our conduct? Processor discipline. Does every processor operate under a data protection grade contract? Accuracy. Do our decision-driving data sets have quality controls? Erasure. Does data actually die here, downstream included? Safeguards. Could we evidence reasonable this afternoon? Breach intimation. Names, clocks, draft ready. Grievance. Does the mechanism work when tested, not exist work? Published human. Could a customer find the name and reach it in 2 minutes? 8 questions, 8 honest marks, and you've just refreshed half the self-assessment from episode 13 with the statutory anchor now visible behind each square. Tomorrow, the quality duty gets its close-up: accuracy and completeness, why the law aims this obligation at decisions and disclosures, what it means for credit, hiring, and insurance, and how the correction right you'll meet later in this arc turns your customers into your data quality auditors. That's today's episode of DPDP Daily. If it made this law a little clearer, do one thing for me: send it to one person who needs it. That's how this show grows. Everything I covered today, with the templates, checklists, and audit frameworks behind it, is in my book, the DPDP Act Compliance Handbook: From Law to Ground Reality. And I post one practical DPDP insight every morning. Find me on LinkedIn and on X and Facebook as well, under Harmeet S. Kapoor. One important note: this is education, not legal advice. For decisions about your organization or your rights, take proper professional advice on your specific facts. New episode every day. I'll see you tomorrow.